Welcome everyone to this new Privacy Espresso. I'm very happy to welcome with us today Robbie Grant, associate at the law firm McMillan in Canada. The exclusive law firm member for privacy rules for the Canadian jurisdiction, is one of the strongest in the country, and actually it has a very robust privacy team, and we are very happy because Robbie is part of it. So we are having this Privacy Espresso because recently there was a draft bill in Canada, and we would like to learn more. So Grant, the question is, what's the current regulation related to cybersecurity in Canada, and why have we come to this new bill?
Well, first of all, thank you so much for having me. I'm very excited to be here on privacy rules. So yes, let's talk about the broader context quickly. It's common knowledge, I'm sure, among all the people that you get on privacy rules and the privacy sector in general, that cyber attacks are on the rise. Every year they appear to go up. Cyber criminals are getting more active, more sophisticated, and more ruthless. Furthermore, as the Russia-Ukraine conflict has demonstrated, modern warfare is fought both on the ground and over the internet, and cybersecurity is a matter of national security. So against that background, the federal government of Canada is proposing Bill C-26, an Act Respecting Cybersecurity, and the bill aims to provide a framework for the protection of critical cyber systems of vital infrastructure in Canada. So I should say at the outset that this bill focuses on federally regulated businesses operating that vital national infrastructure. So specifically, it's catered towards 4 sectors right now: finance, energy, transportation, and telecommunications. So why don't we talk about the current regulation of those industries in order to see what this bill adds to the picture. Cybersecurity standards in these industries come from 2 places primarily. They come from privacy laws and then regulator guidance. Both of these lack significant enforcement mechanisms right now and investigatory powers. In terms of privacy, organizations in those industries are subject to different privacy legislation depending on the province, but primarily, they're subject to Canada's federal privacy law, which is PIPEDA, the Personal Information Protection and Electronic Documents Act. PIPEDA has some requirements. They're very general for cybersecurity. For instance, it requires that companies safeguard personal information with physical, organizational, and technological safeguards. But there are some gaps in PIPEDA, which Bill C-26 appears to aim to address. First, it's entirely focused on personal information, so it's not aimed at preserving the operations of these companies. Second, it's managed by the Office of the Privacy Commissioner of Canada, which, like a lot of privacy regulators, has a huge oversight, right? It's dealing with more than half of the companies in Canada, public and private. And so it does not have the capacity or resources to go in and investigate these vital players to fix up their cybersecurity programs. It's typically much more reactive to complaints or data breaches. And then the third thing is enforcement. The Office of the Privacy Commissioner only has the ability to conduct investigations and make recommendations. It doesn't have significant enforcement powers, though I will say, as an aside, amendments to the federal privacy law proposed in the very same week as this bill, coincidentally enough, would bolster the enforcement regime dramatically, but I'm sure that's a topic for another espresso that I'd be happy to be brought on for. But anyway, that's privacy law. The second way that these industries are regulated is through regulator guidance. Each of these sectors has their own regulator, and these bodies often also lack investigation and enforcement power. So enter, finally, Bill C-26 comes with the potential for significant government oversight and intervention in cybersecurity with enforcement powers. It allows the government to backstop these national operators to ensure that they're taking all necessary steps to protect not just the personal information that they carry, but the continued operations of their services. So put another way, this is not a privacy protection bill. This is a national security bill, which will have the added effect of enhancing consumer privacy. I guess to return to your question about the regulation in Canada and then how do we arrive to it, I wasn't in the room with the drafters of this bill, but the fact that this bill is aiming in this direction demonstrates to me that the federal government feels that their critical national infrastructure in Canada is more vulnerable perhaps than it ought to be. from a cybersecurity perspective. And so they think government intervention is the answer.
Thank you very much for these. And I believe that I can agree with your intuition, not related to Canada specifically, but certainly internationally. We are seeing these happening pretty much everywhere. And many countries are already trying to fix the issue in light also of recent sad news coming, in this case from Europe. I would have another question for you, if you might manage to concentrate the answer in a snapshot. If you can take us into the granularity of this bill, if you would mention really the key elements really in a second.
So it's got two components. The first part is focused on the telecom industry specifically. It would amend our Telecommunications Act to give the Governing Council and Ministry of Industry significant oversight powers. They're effectively empowered to order telecommunications service providers, TSPs, to do anything or refrain from doing anything that, in their view, is necessary to secure the Canadian telecom system. Those orders would be backstopped by significant administrative monetary penalties, in which organizations could be forced to pay up to $10 million for an offense. The second part, it would enact the Critical Cyber Systems Protection Act, the CCSPA, which would create a whole suite of new obligations for designated operators managing these vital services and systems in Canada. So those would include requirements to establish a cybersecurity program if they don't already have one, take any steps to mitigate supply chain risks that are identified by that program, report cybersecurity breaches or incidents, and then comply with any directions imposed by the Governor and Council. And then sort of connected to all of those requirements, you got more powers created for the minister and regulators, including powers to investigate, make orders, and again, issue significant fines for non-compliance. In that case, up to $1 million for individuals or $15 million for anyone else.
That's sounds severe, especially considering the past in Canada. So evidently there is the level of penalties actually is increasing, which again is a phenomenon that we are observing all around the world. Again, in a minute, in your opinion, so pending the bill, so we don't know whether it's going to change, if it will be eventually approved, and in which format. What should companies do to maybe start preparing for it, or otherwise, how they should see the future?
Right. Well, first of all, we don't know exactly who the bill will apply to just yet. We know it's the industries, but then there's also designated operators, and they have not shown what those designated operators are going to be. But suffice to say, if you're a big player in any of the 4 industries I named, the bill will probably apply to you. And then it's sort of obvious to say this, but cybersecurity should already be a huge priority for these companies. Suffering a cyber attack has huge ramifications. So if you're a national company in Canada who would be subject to this bill will just put added pressure on you to formalize, review, and fix up your cybersecurity program to the extent you aren't already doing that. So I guess the big takeaways for me would be revisit that recent audit report, fix any vulnerabilities identified in your system. If your IT team has been for years saying we need to upgrade this, we need to overhaul this whole system, now is the time to invest the resources to do that. And finally, I would say pay attention to the regulator advice. Each of these industries has their own regulator, and many of them have issued cybersecurity guidance. Those regulators, if the bill is passed, are going to have more investigation and enforcement powers. And so go to the source, read that guidance, and make sure that you are complying with it.
Robbie, all of them excellent pieces of advice. Indeed, all of them actually, and in particular, listen to the priorities, and if you have previous audits and previous plans, actually this is the time to implement them, is key. And we keep on repeating the privacy rules. It's key to back on true expertise, legal experts like you, like your colleagues at McMillan, and cybersecurity experts, even outside the companies, because definitely knowledge, it's something that is not necessarily created just inside in-house, but actually needs to back from the expertise of others outside. So for everyone in the audience, we strongly recommend to contact Robbie Grant at McMillan and his colleagues for privacy advice in Canada. And possibly, let's meet again for another Privacy Espresso for how this bill eventually will be adopted, if, and any other Canadian piece of legislation and important updates. So Robbie, thanks a lot again for being with us today.
Thank you so much, Andrea. This has been a blast.